controlled substance or counterfeit substance. I'm sorry. That is Schedule 1, 2, or 3. I'm going to take just a quick look, go over the PSI that I've gone over. I know I made a few notes, but I don't think I made many. One moment. I guess I didn't make any. That's pretty rare. Well, I'll be darned. Mr. Blazak, looks like you did it. Sorry, I didn't mean to seem surprised, Mr. Blazak, but you're starting off the year with a good report so far. All right, good enough. Thank you. All right, let's turn over to the people. Mr. Ringstrom, do you have any amendments, corrections, or objections to make to any contents of this report?
I do not.
All right, Ms. Counsel, how about you? Same question.
Your Honor, we would be requesting an adjournment. We received the pre-sentence investigation report on Tuesday at about 3 p.m. I immediately reached out to the prison to set up a time to speak with Ms. Jacobson and go over this. I didn't receive a response. I called on Friday, and then the warrant allowed me to call her on the phone for half an hour prior to the sentencing, and they didn't have me on the list for that either. So I've been unable to go over this report with her at this time.
Well, that's very unfortunate. All right, so one moment here. All right, what I was looking at, Ms. Castles, was to make sure I recalled what Ms. Jacobson's status was. And I know that she is not entitled to credit because she's currently serving a prison sentence. What I want to highlight to you to please make a note for next time, and I want Ms. Jacobson to hear this. I want you to be able to ask and argue for some credit. Meaning if it takes us another week or 2 weeks, that is a prejudice to Ms. Jacobson because of the inability to communicate or coordinate that meeting between you and Ms. Jacobson. Well, sure, I know, I don't think it was malicious, but with the holidays, who knows, short staffing. But regardless, today I would be given a sentence, and today I would be given 154 days of credit that she earned before she started serving her sentence. If it takes us a couple of weeks, I only think it's fair that I give her some credit for the couple of weeks. So please remind me of that. I want Ms. Jacobson to understand that as well. As a judge, I think it's the fair and appropriate way to look at it and deal with it. So I will make sure I do so. Any questions about that, Ms. Castles?
No, Your Honor. Thank you. I appreciate that and will do so.
Sure, no problem. All right, Ms. Jacobson, have you been able to hear me today?
Yes, sir.
All right, good enough. Thank you very much. All right, thank you. I will have it rescheduled and we'll get it set. Thank you for your time. We are
Thank
adjourned.
you. Yeah.
When was the last time you spoke with him?
Last night,
Oh, all right.
once in like since the last time we had court. But yeah.
Yeah. Did you have a physical copy of the report to go over?
Mhm.
Okay. Well, it is a bit snowy out there today. I think we got 6 inches, 3 inches at least.
Those schools are closed.
Yeah. The main roads are fine, but there's still snow. So it's only coming from Traverse. All right. So what I want to do, because I don't want to rush him and I don't want to rush you. I don't think it's fair. Because I want him to be able to lean over and talk to you if he needs to ask you a question. Maybe you've got something, hey, I need to change this. You wanted to ask him a question. So what I'm going to do is I'm just going to take a brief recess here. Oh, no, never mind. We all got excited. All right. So I'm just going to take a brief recess because I don't want anybody to feel pressured when they walk in. And sometimes attorneys, when they walk in late, sometimes they pucker when they see who's waiting for them. Maybe he won't. I don't know, but that's what we're going to do. All right. Okay. We're back on the record this morning now for the 28th Circuit Court here in Wexford County. And our next case for the docket this morning is people in the state of Michigan versus Molly Marie White. The case number here is 25-3614-FH. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, the Assistant Prosecutor for Missaukee County.
James Dick on behalf of Ms. White, who's sitting to my left, Your Honor.
All right, thank you. Also here before the court is Mr. Luke Blazak. He is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. We are here today for a sentencing on this case upon a conviction of, by a jury trial that was held on November 19th of 2025. Counsel approached me in chambers and told me that there was a request to be made by the defense. Mr. Dick, you may begin.
Yes, Your Honor. There is, before the court today, a motion to withdraw as counsel in my representation of Ms. White.
Is that being made by you or is that being made on her behalf, on her request?
At her request, Your Honor.
Okay, and I'll go ahead and ask Ms. White some questions. Thanks. Ms. White, please raise your right hand to the best that you can. You swear or affirm the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you, man. Lower your hand. All right, Ms. White, is it true that you wish to let Mr. Dick go and no longer have him as your counsel?
Yes, sir.
Okay, you understand that we're here today for sentencing,
Yes, sir.
and are you requesting then to represent yourself?
No, sir.
All right. Well, what, for what reason or reasons are you requesting to excuse Mr. Dick from representation?
Ineffective assistance to counsel, lack of communication.
Okay. Let's talk about the lack of communication. In this, the only thing I'm going to focus on right now is the pre-sentence investigation report. Did you receive a copy of it physically prior to today?
Yes, sir.
And did you yourself go over it by yourself?
With Mr. Dick.
All right, so, all right, I know you went over it with him. Have you gone over it individually by yourself since you had it, or?
No.
No, all right. So then you went over it with him, and was that, I think you told me earlier off the record that that was yesterday? That's a yes?
Yes,
Thank you. And was that by telephone, in person, via Zoom?
in person.
And that took place here at the Missaukee County Jail, is that correct?
Yes, sir.
And when you went over the contents of the report, did you have noticed any things that needed to be corrected?
Yes, sir.
All right, which portions or things did you wish or think needed to be corrected?
They're all written down.
I'm sorry?
They're all written down.
Okay, well, let's take maybe a look at just those points first. Now, hold on, and when I go over this, besides potentially disagreeing with what the jury found, those facts, I've got that. But that's something that the jury found, and I can't challenge that today. Well, let's see what things you think need to be changed or with which you have an objection. All right, Mr. Dick, do you have those written down?
Yes, Your Honor.
Why don't you go ahead and tell me what those are?
The corrections that would be asked for would begin on CFJ 145, page 1, Your Honor.
Okay,
The jail credit days, it's noted in the box that it says 67 after her Ms. White's bond was revoked, including today, they should reflect 68 by my calculations.
we don't count today because the day you actually get the credit today. So when the form is prepared, it's through until today, and then that credit will be added by the sentence, or I'm sorry, from the jail. But you already get credit. What often happens here is when the reports get prepared, people don't understand it's through until today. So you actually will get credit for today. You're not going to miss that. That will be given to you, but it comes after today. So, all right.
There was, Your Honor, on CFJ 284, page 10,
All right, I am there.
there's a statement in there.
Underneath which entry? That's,
The first box that has a narrative.
yep, underneath, which is, looks like criminal history entry 6 of 31, which begins on page 9 and continues on to page 10. Yes, sir.
My apologies.
That's okay.
It says in there, assaulted a Cynthia Bethy on 6/18/10. There are no charges or anything reflected in the PSI on that date or anything that would reflect that
Well,
incident.
Let's take a look here. So what we have is that there was a probation violation. We don't see any criminal history entry for, say, an assault. One moment. You don't need that. I would say that, and I'm going to turn to Mr. Blazak and ask him a question in just a moment, but for somebody to be found guilty of a probation violation, the burden is not proof beyond a reasonable doubt. It's by a preponderance of the evidence. And we know that the rules of evidence do not apply at a probation violation hearing pursuant to Court Rule 6.445 and MRE 1101. So we know that dependent upon the degree of the assault, whether or not the person showed up at a trial, whatever, there's a whole lot of reasons why there may or may not be a conviction or even a charge. But there can be a probation violation. So let's take a look here. And by the way, this would have been done back years ago, and there have been no changes since. The court would assume that there was no, there may have been waived, but anyways, let me turn to you, Mr. Blazak. Do you have any information about that?
Just that this was the notes about the, how the defendant did her time in this particular instance. It covers a broad span of time and her behavior. Looks pretty complete and detailed. I don't really have anything to add or anything that I would take away from that.
Let's take a look at where that was done. Well, that was in Wexford County. It looks like the 28th Circuit Court over there. So, all right. The point there is, so the point is I would need to have something to say that it did or did not occur, that there was a probation violation finding. And so far it's telling me that there is a finding. It doesn't need to have a criminal conviction. So at this time, I'm going to deny any challenge there. Highlight, however, it's a relatively minor consideration considering how many other violations there were detailed in that paragraph. All right, let's talk about the next one.
Yes, Your Honor. Likewise, in the same box, there was another one that we were going to address. It was the Richard Kavanaugh assault. It's 1, 2, 3, 4.
Yep, I see
5
it.
lines down. And understanding what you just said, I believe that will also be.
Yeah, well, again, whether or not she was convicted of it is not the question.
Yes.
Whether or not she had a probation violation is the question. And I see here that, for instance, on this one, it says that there's a probation violation on March 18th of 2012, where she changed residence without permission and assaulted Richard Kavanaugh and received 30 days of jail. So the challenge is not whether or not she was convicted of a new criminal offense underneath another case. It is whether or not she was found guilty of a probation violation. So I don't have any grounds to demonstrate that there wasn't a probation violation. Yes, I understand that there was no conviction of a new crime. There doesn't need to be a conviction of a new crime. All right, let's take a look at the next one.
CFJ 284, page 22, Your Honor.
23, 1 second. All right, I'm there.
Under the marriage section, the very bottom box on page 22.
Oh, you said 22. I'm sorry, I went to the wrong page. 1 second. All right, I'm there.
The very last box says white Nadia.
Mhm.
Daughter's name is not Nadia Porter and not Nadia White. So it was a repeat with the incorrect name.
So it's Porter, Porter.
Yes, and it is correct on page
Oh.
23 as that box continues over, Your Honor.
Oh, so there's not a Nadia White and a Nadia Porter. All right, so we will go ahead and did she go by Porter or White? We'll cross off that line on CFJ 284, page 22, underneath the marriage, where it has Nadia White. We'll just cross that out. I see.
Yes, sir.
Thank you. Next one.
CFJ 284, page 23. Your Honor.
Okay, I'm there.
The marriage narrative, the third line down, says Braden's father is John Darcy. It should reflect David Jensen, but the defendant said John Darcy, physically forced her to sign the name.
All right, so
the-
the only thing that needs to be changed are the switch the names around.
Yes,
Okay, and I see Miss White shaking her head, yes. All right, Mr. Blazak, can you just switch those two names on that line in CFJ 284, page 23?
Yes, Your Honor.
Copy that. By the way, I saw that there was someplace here, 1 second, reference to the defendant considering a common law marriage. Let me find where I saw that. I don't know. I don't think I've ever seen that. It's not supported there. So let me take a quick look. Where did I see that? One moment. I know I put a question mark next to it. Oh, on CFJ 145, page 1. Underneath personal history, it says marital status, common law. I don't know. Ms. White, do you believe? I've never heard, it's not mentioned anywhere else. I've never seen a significant other. All right, so she's shaking her head. No, we can strike that off. She is unmarried or single, right? Single. Are you divorced? No, she says no. So we're just going to change that from common law. You don't really see that here in Michigan, but okay, that took care of that. Next one, Mr. Thick.
CFJ 284, page 24, Your Honor.
Okay.
Under substance use. Beside the drug methamphetamine, it has a start date of 4/26/2023.
Yep, that's the same start date on CFJ 145, page 1. I put a question mark next to that because I thought there was a prior conviction before.
Yes, Your Honor. This should reflect likely 2008 as a start date.
All right. So, Mr. Blazak, on both of these two pages, again, CFJ 145, page 1, and CFJ 284, page 22, there should be a start date of somewhere around, I'm sorry, during the year of 2008.
Yes.
All right, and then do we want to give an end date of 2000 of some time?
March 20.
Well, let's not pick the trial. Let's not pick that date. Let's just say, we'll say as of today, or we could even just do a year. You know what? I don't know.
2000.
Hold on. Let's leave it blank because of her interest in appealing. Okay? She's shaking her head, yes, smiling. She's picking up what I'm laying down. All right. All right. So anything else?
Yes, Your Honor. Under substance abuse treatment
Sure.
in the box, inpatient, if you slide over to the
End date.
start date,
Mm-hmm.
it reflects presently October 1st of 2025. It should reflect 2024.
I had a question mark there as well. All right, and did she complete the program? It says yes, so there must be an end date.
Yes, Your Honor. The end date, she believes it was October 28th of 2024.
All right, October 28th, is that you said?
Yes.
All right. We'll go ahead and put that in. You got it, Mr. Blazak?
Yep.
Next one.
And then just below that in the narrative, it reflects October 25.
Yeah.
Which should reflect
Yep, we'll make sure that gets changed as well. Thank you. All right, anything else?
And that is all, Your Honor.
All right,
I have noted.
thank you. Now, that's all that Mr. Dick noted. Go back to Ms. White. Were there any other corrections, objections, or amendments that you caught that Mr. Dick didn't cover?
No,
All right, thank you.
I mentioned them when I seen them to him.
I'm sorry?
I mentioned them when I seen them to him.
Great, perfect. Thank you. All right. So now I've got to go back to your original question here today. What I'm looking at here is whether or not to excuse or order with the withdrawal of Mr. Dick as your counsel. Then the next question is, do you then wish to represent yourself or have a new counsel appointed? Now, I'm not likely to appoint a new counsel because we're already past the trial date and you've already covered all the corrections or amendments that you had. The only thing that's left for him is to make an argument about what to do or not to do on sentencing. At the same time, I would tell you that you do have a constitutional and legal right to represent yourself. You already know the charges for which you've been convicted, which was a possession of the controlled substance methamphetamine as a fourth habitual felony offender or a second or subsequent drug offender, which initially the maximum punishment is up to 10 years. However, based upon the enhancements as a second or subsequent drug offender, it could be increased to 20 years, or as a fourth habitual felony offender, it could be increased up to life. I have not heard any challenges to the scoring of the guidelines. I'm going to turn to Mr. Ringstrom in just a moment, but I can't imagine that he has any. The reason why is because the offense variable score is 0. So there's nothing to challenge there. It's already the best you could get. The only challenge then would be as to your prior criminal history. And at 117 points, you are well into the PRV category F, which begins at 75 points. So you're already you'd have to get rid of 47 points for there to be a difference. And I don't see any challenges to those scorings. So let me return to back what I was saying. Again, we have also talked, I'm sorry, you've seen the scorings. That is the minimum guideline ranges from 10 months to 46 months. If you represent yourself during sentencing, you'll be expected to comply with the same court rules and how the case is conducted. The only court rules really left are your ability to make an allocution, in other words, a statement, if you choose to do so. And your counsel can make an allocution. You still will be expected to comply with the rules of evidence. Although the rules of evidence do not apply at a sentencing hearing pursuant to Rule of Evidence 1101. I can, of course, give you the opportunity to consult with a retained lawyer if you choose to do so. However, the question is would the court have the matter appointed? Or have another attorney appointed? If I recall, there were multiple defendants in the same series of events. And we don't that's exhausted at least all the current public defenders through the Wexford Misaki Public Defender Program. And we have to go to the conflict counsel for a new attorney. One moment. Have you spoken to any other attorneys, Ms. White?
I have not.
Okay, I know there was another counsel. I'll be darned if I can remember his name and I'm not being rude. Yeah, there we go. I knew if I remembered it, there was no way I was going to get the pronunciation correct. Have you spoken to him at all since the trial?
I have not.
Okay.
Let me retract that statement. I have spoken to him. I have not spoken to him about the case.
Okay. So there's a recent case that actually got sent back by the Court of Appeals actually to me where a defendant withdrew his right to have counsel, chose to represent himself, and I can't remember what the court said I did wrong, which I remember thinking to myself, I couldn't advise him of too much because there's no rules that apply anymore, other than the right to speak on your own, the right to speak on your own behalf. And you've already gone over the PSI with Mr. Dick. So the question is what do I do? So I would really like to see the opinion of the guy. That was in this case. No, that was in this courtroom.
That wasn't Moffett, was it? Moffett?
I think it was. Yeah. Could you, we're gonna take just a brief recess. I'm gonna have Linda, the deputy clerk here, pull up that case. Because I remember thinking to myself, how could it be kicked back? Because I mean, I guess I could kick it because it doesn't really matter to the court because you're not going anywhere. You're just gonna sit here until I get another counsel, which could take 30 days. Theoretically, I guess you could file a motion for a new trial. Anything to offer, Mr. Dick? Anything further? Move to, well, there's no sentence, so you're not correcting a sentence. You always have the right to file it for a new trial. Did you fill out the form for, no, you haven't yet,
Yeah.
but I think we've already started doing the transcripts. Am I correct, Nancy? For the trials? Yeah. All right. So what I'm going to do is I'm just going to put a brief recess here, a couple minutes. I see Linda, she's getting her steps in again. She should thank me. But she never does. So what I'm going to do is I'm take just a brief recess, have Mr. Dick remain here with us in the courtroom. I'll leave it up to the corrections officer about what we need to do with you, whether you leave here, but I don't think we have deputy, do we have any other correct? We don't, not until we get to Malachi. So can we, whatever, you're in charge of Miss White, I'm not. All right, so we'll just take a brief recess. I want to read that opinion that the court had. I don't really remember it. I can't imagine what there would be appealable, but anyways, I'm not that smart. All right, we'll take a brief recess for 5 minutes or so, maybe 10. I'm going to pull up the next case. Thank you. Yes, Mr. Brown?
Yeah, Pro John?
Yeah, of course. All right, let's get our lawyers, let's get our prosecutors back. Here you go. All right. Nancy? We're back on the record for People versus White. All right, I do recall that opinion, and I did take a look at it. And the opinion only sent it back to allow him to be represented at a resentencing because the court allowed him to represent himself, even though I made a finding that he clearly understood his right, and that he would have to comply with all the rules of evidence. Of course, they don't, which again, underneath the court rule, it doesn't make any sense because there are no rules of evidence. It talked about making sure the defendant knows they've got to comply with the court rules. Well, the only rule left is to make an argument or an allocution. It seems to be a bit silly. However, in that particular file, the only thing that they said, and I'm not trying to be disrespectful at all to the Court of Appeals, I trust that they are much, much more intelligent than I am because they have cooler offices than we do here in Missaukee County. But, and I'm saying that with some tongue in cheek, okay, to read my comments. The question is would it unduly burden the court? So I'm going to turn to Miss White. Miss White, are you asking still to have Mr. Dick excused? The only thing left to do is argue. Just tell me yes or no. I don't particularly care what you do. So you've said yes?
Yes.
All right, thank you. And do you wish to have the court appoint another attorney to assist you for the sentencing?
Yes.
Now, the question there is, does it unduly burden the court? Personally, I'm sorry, not personally. From this vantage point in this courtroom, having dealt with this case and so forth, it seems to be a bit, I don't want to use the word silly because the right to representation is constitutional, due process, Sixth Amendment, got all that. But it just seems to be that we're here for a sentencing, but because I don't want the case to be kicked back, and the key phrase unduly is what I'm going to reference now. Ms. White, you still have another case pending, correct?
Yes, sir.
And do we have a trial? We must have a trial date for that, right?
Yes.
Yes, February 17th, 18th, and 19th.
Are you representing her on that file?
Presently, same motion will be made.
Thank you.
Yes.
So that's what I'm going to do next. I'm going to call that case number in just a second. So because she has another case pending, and if I were to sentence her, she would theoretically, based upon the sentence, most likely might involve a prison term because you're already at the 10 months. So as long as I go 13 months, for example, it'd be a prison term. Well, it would probably be unduly burdensome on the county to have to, or to the Department of Corrections to have you shipped back and forth for different trial dates. So therefore, the court will grant the motion, allow Mr. Dick to, allow him to be excused, recused from the case, no longer representing Miss White on this. We'll have it set for, or have another defense attorney appointed to assist her only for these particular purposes. I say these, I mean sentencing. Now, Linda, can you pull up what the other case number is?
3619.
So the court next calls the case of 25-3619 FH. That is again, the people of the state of Michigan versus Molly Marie White. Counsel are still here. Mr. Ringstrom on behalf of the government, although it might be Mr. Denhout. Nope, Mr. Ringstrom is still the big dog on that file. And Mr. Dick is here as a defense counsel and Ms. White is here. All right, now, because it's a separate record, I'm going to reference. We have just moments ago addressed case file 25-3614FH, in which Ms. White was here today, or is here today, for sentencing after a jury trial. And in that file, Ms. White asked to excuse Mr. Dick as representation for her on that case. Is that correct, Ms. White?
Yes, sir.
Oh, thank you. All right. I don't think I need any further argument or discussion. Mr. Ringstrom, do you have anything to add today? I didn't mean to ignore you.
The matter like this is between the defendant and the court, not the
I
prosecutor.
know, but I don't want you to feel slighted and
Yes.
here. So anyways, all right. Mr. Dick, anything further to add? Did I state everything correctly? We're seeking to excuse you.
Yes, Your Honor.
Okay.
And would the court like me to draft the orders?
Linda? Can you do them or
Usually Nicole
Okay.
prepares an order.
tell you what? I've got great staff. We're gonna make sure they do it. But what is that other file again? Oh, wait, 3619. F8. You're earning credit. You've already served that other sentence, correct?
Yes, sir.
Yeah, good, copy. All right, so the court will, again, in each file, 3614 and 3619, grant the defendant's motion to excuse current defense counsel, and the court will have new counsel appointed to assist. The court will have this matter set for another sentencing date. And of course, with that new file, maybe Ms. White's new attorney would like to adjourn the sentencing. Well, I don't know, it's up to her, but up to them, but maybe that's something we can consider. All right. Anything else on behalf of the government? Mr. Ringstrom?
No, Your Honor.
How about you, Miss? Well, no, actually, you're excused. Miss White, anything else?
No, sir.
All right, thank you very much. We'll see you all whenever my secretary says.